Hello everyone, it's Ulysses here from SSW TV and I'm here with Cameron.
G'day Yuli, how you going?
Good. We are talking today about the terrifying and shouldn't be so terrifying and should be fascinating topic of NDAs, or non-disclosure agreements and confidentiality agreements. Now, just for context, I'm running a software consultancy and I have to sign these a lot, but they're all pretty similar. And after having done them a lot now, it's very, very quick and very easy. And I remember back in the day when I first started off, they were terrifying things. So we're going to try and demystify them to some extent with a bit of legal help and a bit of frontlines help. So what is an NDA?
Thanks Yuli. Yeah, an NDA is a non-disclosure agreement, or sometimes called a confidentiality agreement. Companies ask organisations like SSW who are providing professional services to sign an NDA before they engage SSW, because they want to make sure that SSW or another professional services company they're engaging doesn't run away and share secret or confidential information with other people.
Yeah, right. Okay, so can you take us through the sort of common sections that we might see and why they should be a red flag or why they might not?
Sure. So every time you receive an NDA, and as a lawyer, I'm always going to say, go and get your own independent legal advice. But I think before you do that, you should be aware yourself of these essential elements, and there's some real gotchas in there to keep an eye out for. And if you see some of these gotchas, my view is before you necessarily go and engage a lawyer, you might say, no, that's no good, send me another version with these things fixed. The first gotcha is to check whether the NDA is mutual or one way. Now, in my view in life, if you have the view that what's good for the goose is good for the gander, then you're more than likely to have an NDA which is a bit more fair and reasonable if it operates both ways. If the other side is trying to get you to sign an agreement where all the obligations are on you or on SSW, then you've got your head on the chopping block. You're the one at risk and they've got no exposure. So if it's a one-way NDA, my view is you should say, no, not happy with that. Can we make one that's mutual?
Yeah. My point of view on that is from a person who's signing it point of view, I feel like if it's two-way, they're less likely to try and sneak something in that's unfair, because whatever they're forcing me to do, they're also going to be abiding by. So that always makes me feel comfortable, just because I know that they're going to be bound by the same restrictions I am.
100%. You've always got to keep an eye out for what lawyers like to call sharp tactics from one side or the other. And if everyone's prepared to eat the sandwich themselves, then there's very unlikely to be a gotcha in there that's only going to capture one of you as opposed to both of you.
Yeah, excellent. All right, what's next?
The second gotcha is to check whether SSW or the provider of the professional services promises to indemnify the other side for loss. It's a complex area of law, but just bear in mind that if you're indemnifying the other side, then you're really exposing yourself to all sorts of loss and damage if you go ahead and breach the NDA. What an indemnity does is expands what your normal obligations under the common law would be. Those obligations in relation to compensating for loss under the common law are limited by things such as what loss is foreseeable or whether some loss is too remote. However, when you promise to indemnify the other side, then those limitations don't exist. And so it could be that your exposure is unlimited.
Right, so is there any particular buzzword like unlimited exposure or anything we need to be looking out for?
The most significant word is indemnity. Some NDAs will include a clause where you indemnify the other, but some NDAs are just silent on the issue. So my view is if it doesn't include an indemnity clause, then the typical or common law approach to damages would apply, which I think would be more favourable for an organisation like SSW.
Okay, so if there's an indemnity clause, be careful with it.
Resist it.
Yeah, push back. Okay, excellent.
The next thing to bear in mind is a time period. Some NDAs have a clause which says that this agreement is binding for 3 years or 5 years. Some NDAs, and I think most of them, have no time period associated. So that's important because it may be that in 5, 7 or 12 years you're still bound by the terms of this NDA. My view would be try and add a time limit to it. 3 years or 5 years I think is reasonable. And I think then you can put things to bed after a few years and not worry about it.
Yeah, and again, if it's a two-way thing, it's more likely that's going to be in there.
100%.
Yeah, excellent.
The next thing is a practical issue, and if you're dealing with a company that is, from your local area, it's probably not going to be a problem, but is to check the jurisdiction under which the NDA operates. So if we're a New South Wales company or a Victorian and Queensland company, my view is you should make the jurisdiction the area where the company has its head office. So for SSW, if the head office is Sydney, then the jurisdiction should be New South Wales. And that means that if there's a dispute about the NDA, that you go to the courts in New South Wales to argue that dispute. If you're dealing with an international company, for example, a company from America, they might insert that the jurisdiction is the courts of Texas or the courts of North Dakota or the courts of New York. And so what that means, it has an incredible practical and cost implications if you're forced to go and travel overseas in order to argue a dispute about the NDA. My view is if you're engaging with an international company, it's probably best to pick a jurisdiction which is convenient for both parties, which might be Singapore, for example. So if you are asked to sign an NDA which has at the jurisdiction Texas, say no, can we make it Singapore? That's a common jurisdiction for the resolution of international disputes.
Actually, one thing on that, I've been caught out once, almost caught out, I managed to spot it, where there was an NDA that specified a specific payment in case of a breach. So rather than saying a certain court will figure out what the payment would be or what the damages would be, it said specifically $500,000 if there's a case of a breach or something like that.
Well, that's a good pickup, Yuli. If you're in the courts of New South Wales or in any other Australian jurisdiction, even if it had such a clause, you could probably argue that that clause was non-enforceable because it would be construed as a penalty when they nominate what's called liquidated damages, where you nominate the sum. If you're in an international jurisdiction where that rule may not apply, then yes, you would be exposed potentially to that sum of money. My view is always resist a contract which nominates liquidated damages. Just like I said before in relation to indemnity for loss, let the law fall where it falls in relation to what loss you are exposed to or the other side is exposed to, not a liquidated nominated amount.
Yeah, excellent. Can I ask a question? I've had NDAs where the company in question has asked me specifically to get the developers who are going to be working on the project to sign individually as opposed to me signing on behalf of the business. And that always feels a bit funny and the devs don't really like it. How does that sit legally? Can I push back and say, look, they don't need to do that?
Well, I guess the point is that those developers then may well become personally liable in the event of a breach. My view is that if that was the case, the developers should seek their own independent legal advice about whether or not they should sign an NDA personally. My view is that the signature of the company ought to be sufficient to satisfy the other side, the client, as to their protection.
Yeah. That's generally been my pushback.
Under Australian and New South Wales law, there's a principle called vicarious liability, and essentially the employer would be responsible for the actions of the employee if the problem arose in the course of the employment. So my view is that the client should be satisfied under those principles that if one of your developers breaches the law, it's as if the company's breached the law and the company should be the one responsible. So I think it'd be very dangerous for developers to individually sign NDAs themselves.
Yeah, beautiful. The way we get around that is we put in our contracts with our employees and with the induction process with the employees to make sure that they understand that any client project they're on, if they don't know if there's an NDA, assume there's an NDA. Just don't share any information.
100%. And this comes down to the question of what is confidential information, because every NDA will nominate what confidential information is and it'll seek to define it or describe it. And what we also need to keep in mind is that often things which are confidential can become not confidential over time. For example, if your client gives you all this information which is confidential, but then goes and writes a press release about it or publishes or creates a product based on all the information that's been provided, then any information which has been put into the public sphere by the client should be deemed to be no longer confidential. So it's really important to ensure that the definition of confidential information also excludes certain things such as any information which the client decides to put out there in the public. One final section to discuss is to check the obligations that you, or SSW, or the software provider has under the confidentiality agreement, and particularly what happens at the end of the project that you're being engaged for. Some NDAs will require that you give back the information that you've been provided by the client, and that's okay if they've given you a manual or given you a hard drive or a USB with data on it, then yeah, go ahead and give it back. Some NDAs will require that you destroy any document that they've provided you. And in my view, it's almost impossible to actually do that these days because there are so many copies and copies and copies of documents and data on our hard drives and in the cloud, on all the employees' hard drives, on their phones and the like. I don't think you should ever sign an agreement which says that you promise to destroy any document or information at the conclusion of the project.
Yeah, it's a good one to look out for.
It's a very simple one, and we just can't promise to destroy things these days.
Yeah, fair enough. Well, the ancient Egyptians used to make traps, and then they would kill the people who made the traps so that no one knew how the trap worked.
Well, if you could incorporate that into your contract, that'd be a great way to make sure the information is kept confidential.
Right, we'll try that next time. Okay. Anything else to cover?
I think that's it.
All right, beautiful. Well, I hope that's demystified things for you a bit. These things shouldn't be that scary. From the consultancy's point of view, generally speaking, you're not that worried about your own confidential information getting out there. So when you read these documents, just think of it from the point of view of someone sharing their IP with me so I can build their software. I need to be responsible with that IP. And this agreement should just cover that we are responsible with that information and what happens if we're not. So long as that's fair and straightforward, and as you said, two ways, it shouldn't be too scary. So Cameron, thank you very much for joining me today.
Thanks for having me, Uli. One final piece of advice. If you're not sure, go and seek independent legal advice, of course.
It's his catchphrase now. Beautiful. That's Ulysses Maclaren from SSW TV. Thank you very much for watching.